Okay.
It'll be 14 is when we start meeting.
2014.
We'll call the December meeting of the Public Pension Oversight Board to order. Please call the roll, please.
Senator McDaniel. Senator Mills. Senator Neal. Senator Nemus.
Present.
Senator Parrott. Senator Thayer.
Here.
Senator Wilson.
Here.
Representative Duplessis. Representative Fleming.
Present.
Representative Graham.
Here.
Representative Petrie.
Here.
Representative Pratt. Representative Weber. Representative Wheatley.
Here.
Mike Harmon. John Hicks. Victor Maddox.
Here.
Sharon Mattingly. Representative Miller.
For the last time, present.
Senator Higdon.
Here.
Representative Tipton.
Here. We do have a quorum. You should have a copy of the November minutes and your agenda. Do I hear a motion to approve the minutes?
So moved.
A motion, have a second? Have a second. All those in favor say aye. Aye. Opposed, no. Motion carries. Before we get into our agenda, we do have some retiring members. The Public Pension Oversight Board, this will be their last meeting. Their term is coming to their end. Their service is ending. So right now I'm going to turn over to Co-Chair Higdon to offer a resolution on behalf of a Senate member who is retiring.
Yeah, thank you, Mr. Chairman. And Dennis Parrott, I don't think is here today. I don't see him. He didn't answer roll. But Dennis has been a dedicated member of the PPOB since its inception in 2014. And he is retiring after December 31st. And he will no longer be serving on this committee. So this was actually his last meeting. And we just want to recognize Senator Parrott for his great positive attitude and his dedication to this committee over the past years, and congratulate him upon his retirement. Thank you, Mr. Chairman.
Thank you. We do have 3 members from the House who are also stepping down. As Representative Miller stated, this is his last time answering roll call for PPOB. He has decided to end his service in the General Assembly. He has been chairman of state government, I believe, for the last 6 years. And in that role has served on PPOB. He and I have had many discussions over retirement and pension issues in that time. He has been a valuable source of information and wisdom and leadership on this issue, and we'll have a resolution for you. Appreciate that. We also have another member who is not coming back, Representative Jim Duplessis. Representative Duplessis had actually served as co-chair. I don't believe he's here today, but there's Jim. All right, I missed you there. There you are. But glad you're here for the final meeting of your term here. But Representative Duplessis served as co-chair of the Public Pension Oversight Board till earlier this year when he stepped down from that role. Again, just a valuable resource. Representative Duplessis and I and others worked tirelessly on House Bill 8, and I want to thank him for his leadership on that because that solved a lot of problems that we really had, and it's moving us in a step forward to keeping our pension system solvent. And we thank you for your service. Also, another member, this will be his last meeting, and he's actually on the agenda today, Representative Buddy Wheatley. I want to thank him for his service as well. He is. We don't always agree on every issue, but we always respect each other's positions. And he has been someone who has valuable insight to these issues, offers his perspective, and he's not scared to ask a question. And we appreciate his service for that. But we do have this resolution. Do I have a motion from PPOB that we adopt all these resolutions by Representative Graham? We had a second, I believe, was that Representative Pratt? Did you raise your hand? Yeah, Representative Pratt seconded that. All those in favor say aye. Aye. Any opposed, no. That motion carries, and we thank you for your service. One other thing, I want to take a moment of personal privilege before we go into our agenda. I just saw the news article about an hour ago, and I want to offer our congratulations to Representative Graham. He'd be taking over his new role as Minority Floor Leader starting in January. So thank you. Congratulations, Representative Graham. Look forward to working with you in that role, and thank you for your many years of service as well.
Mr. Chair?
Yes, go ahead.
May I make a comment?
Yes.
I want to go back to Representative Wheatley. He's been a valuable member of our caucus. The one thing that you have to give him credit for, he's always wanted to reach across the aisle to work with those on the other side, the Republicans on the other side. But he's always been a dedicated public servant. He's been a firefighter. He's also a lawyer, and he has spent the last 6 years here at the General Assembly, serving 4 years. I keep thinking that he's been 6 years. He took over the seat that Arnold Simpson had, and both of those were gentlemen, and they were people who have walked across the aisle to work on building relationships as well as pursuing public policy. So we have had a jewel here representing the people of Covington, and we're going to miss him. But the one thing he can walk away with is that he's always given 100% of his time and his effort in serving the people from his county. So I thank you for your service. I know that somewhere down the road, you will be back in some way, in some capacity. And we thank you so much for your service.
Thank you for those comments, Representative Graham. Now we can get into our agenda. The first item on our agenda is an update on cryptocurrency and Meta Holdings. And first we have Bo Craycraft, Executive Director of the Judicial Retirement Systems. Please introduce yourself for the record and proceed with your presentation, Bo.
Good afternoon. As mentioned, my name is Bo Craycraft, and I'm the Executive Director of the Judicial Forum Retirement System. I have been asked today to provide a brief update on our holdings with regards to cryptocurrency and Facebook holdings, Meta Platforms, which is formerly known as Facebook. Before I did that, I just wanted to echo the comments that we just heard with regards to the specifically the three House members. I know in my prior life, I got the joy and privilege of serving on the Public Pension Oversight Board as one of the nonpartisan staff members here at LRC. And all three of those gentlemen that were just mentioned, I had the honor of working with on different legislative proposals. And so enjoyed that time, learned a lot, and just appreciate all three of you all. With that, the update will be brief. First, with regards to cryptocurrency, I can say we have no holdings with regards to that. It does not fit into the investment strategy that our investment manager, Baird Trust Company, follows. So I don't expect it to ever fit in. It's a very speculative asset type, and they do not do those things that are speculative in nature. With regards to Meta Platforms, or also known as Facebook, we do have holdings in that. In both the Judicial Retirement Plan and the Legislative Retirement Plan, we have about 80 basis points, 0.8% of our total assets is invested in Meta Platforms. As you all know, our equity portfolios are benchmarked to the S&P 500. And that's a very equivalent weight to that of Meta Platforms in the S&P 500. Currently, I think their weight in the S&P 500 is about 83 basis points. And so, very, very benchmark-like with regards to that holding. Total dollar amount on JRP is just over $4.2 million, 36,222 shares. On the legislative retirement side, it's $1.2 million, a little over 10,000 shares. I think a memo for myself has been included in your material with those exact dollar amounts. With that, I'd be happy to answer any questions if there are.
Do any of the members have any questions? Yes, Co-Chair Higdon.
Thank you, Bo. you gave us the value. What was the going in value on the Facebook Meta stock and where it stands now? How much how much exposure
Yeah.
do we have there?
No, I mean, we're net that it's not a net winner. Like I just have the judicial retirement plan. Our net cost right now is 4.2, and our invested cost is about 8. So it's down since we initially purchased it.
Okay, so down from 8 million to 4 million.
Right now, I did not go back and see where we've sold. We've definitely rebalanced the portfolio at least 4 times since 2020, just because the equity markets have really grown. So it's probably less than 4 million because we have sold at times, especially when markets were up.
Thank you, Mr. Chairman.
Any other members have any questions for Bo? Well, thank you for being here in your presentation. Next, we'll have members from the investment staff at KPPA. Please introduce yourself for the record and proceed. Make sure your microphone is on and close to you. You'll
Yes,
have a
sir.
green light lit up.
Can you hear me?
Yes.
Okay. Good afternoon. My name is Joe Gilbert. I head up the public equity efforts at KPPA. Mr. Eager and Mr. Willer, unfortunately, were not available. Mr. Eager, I think, might be doing some traveling on vacation. So I get the pleasure of sitting in this seat on their behalf. So I appreciate the opportunity. With regards to the 2 questions on the agenda, from a cryptocurrency perspective, no plan administered by KPPA has any direct exposure to cryptocurrency, nor does any plan have any direct exposure to any cryptocurrency exchanges. In terms of Meta platforms, we do have exposure. Because of the way we're structured, I can do this on several different levels of detail. I'll start at the very top level and see if that's sufficient for this committee. If you were to roll up all accounts across all plans, both pension and insurance, as of November 30th, we had just under 270,000 shares. That had an approximate market value of $31.9 million and would represent 0.14% of the total assets under management at KPPA. From a plan perspective, the 5 pension, the 5 insurance, the weight would range anywhere from 0.1 to 0.5% of any one of those plans, and that's in the difference being different targets to public equities based on funded ratios and cash flow needs. So that's all I had prepared. I'm happy to take any questions on that.
Co-Chair Higney.
Always like to hear dollars and cents. What type of losses we're talking about? I understand the percentages, but
Okay.
still, my mind works better when we talk in dollars and cents.
Okay. I don't know if you want to talk about the specific holdings we have today, or if you want to say what was our largest amount of holding. If you want to know from a total,
Just primarily as of today.
okay.
What is that investment cost us?
As of today, the 31.9 million had a cost basis of 44.8 million, so we're down about 12.9. It's currently held in 4 different internal accounts to our passive S&P 500 replicating strategies. We hold, as Mr. Craycraft said before me, the index holds that at 0.84%. Those accounts hold Meta platforms also at 0.84%. 2 accounts are internal factor-based portfolios, and they hold the security at 0.24%. So we're a little underweight from a risk perspective in those particular accounts.
Okay, thank you, Mr. Chairman.
Joe, from a historical perspective, say the last 12 months, last 2 years,
Yes, sir.
What has the value of those holdings been, and have they been on an upward or downward trajectory?
Okay. I can't hardly see my notes in front of me, but at a high, both in terms of number of shares and market value, would have occurred in December 31, 21. We had just over 346,000 shares. That is at the top line, rolled up across all plans, across pension and insurance. At the time, that had a market value of $116.4 million. The cost basis on that was $67.5 million. So at that moment, we had almost $48.9 million unrealized gain on the assets. Those were held in 10 different accounts, 6 external, 4 internal. The external managers have exited that position over the course of 2022 as their thesis started to deteriorate with the shares coming down. And so at the time, they had roughly, I don't have it in front of me, here it is, $44.5 million was invested in Facebook of our external managers, and about 11 million of that was unrealized gains. So I believe they did have gains on the investment. Unlikely that it was that 11 because it would have been deteriorating over 2022 as they were exiting the positions and multiple sales. Does that address your concern?
So 2022, we have seen a definite downward trajectory. Any opinions on where that trajectory is going in the future?
Specific to Facebook or Meta? Well, my last external manager that held the security, I'm actually scheduled to have a call with them middle of next month where we do our quarterly calls. They exited the position in early October, so I'm going to get their opinion. I think in general, anything that was a growth-related stock, late 21, got hit really hard as central banks started to ratchet up rates. Most growth stocks were probably priced at a premium, and their multiples decompressed, so that hurt all growth stocks. I think Facebook in general got hit much harder. I think they're down about 65% on the year versus a market of about 18. That has to do with, I think, their switch from their core competency of social media and revenue ad share, and they kind of moved into that metaverse, which has been a pretty expensive venture for them and has been very damaging to their margins, and so I think that's why they themselves have been hit. That ad spend is coming down as the global economy shrinks, and there's more competition for those dollars. So I think they're going to have a rough time. I think J.P. Morgan upgraded them last week, thinking that most of that pain has now been priced into the stock, but it was not a significant upgrade. So we're unlikely to hold it in excess of market risk at this time.
Seeing no other members with a question, thank you. Oh, yeah, I'm sorry, I got Chairman Petrie.
Very quickly, you had mentioned back on cryptocurrencies for just a moment, no direct exposure.
Chairman, you turn your microphone on, or
It
headphones?
is. It's probably just not close enough.
Thank you.
There we go. You mentioned no direct exposure on cryptocurrency and no direct exposure on crypto exchanges.
Right.
What's the level of exposure on indirect with crypto and the exchanges of it?
The reason I said the word direct was mainly to cushion me against someone who says you have some exposure somewhere that I'm unaware of. So I would imagine all of the pension funds have some kind of tertiary exposure. Some customer of J.P. Morgan probably has a revenue base based in cryptocurrency. We hold J.P. Morgan. It's my way of saying directly we hold nothing of that nature, but I can't promise that there's not derivatives down the pipeline that have some type of exposure to
So
that.
no appreciable risks.
Correct.
All right, that's all. Thank you.
Co-Chair Higdon.
Thank you, Mr. Chairman. Joe, you mentioned internal and external
Yes, sir.
managers. What's the percentage of external managers, or assets controlled by an external manager versus what's controlled by an internal manager?
Right. Okay. So we view our risk dollars a little differently. We spend them where we think the markets are least efficient. We view U.S. Markets primarily to be the most efficient, especially in the large cap. So we have no real active management in that. We have our active management down the market cap, so small caps, micro caps, those type of things. So on our U.S. Equities, we're about 70% internal, 30% external. It's a kind of an inverse of that on the non-U.S. space, where we view that to be less efficient. So in the developed countries, we have one passive external mandate that's about 28 to 30% of the holdings. The rest, the balance, 72% is going to be actively managed as you get into the less efficient markets, such as emerging markets.
Thank you. Thank you, Mr. Chairman.
Don't see any other questions this time. Thank you for your presentation, Joe. Next, we have Bo Barnes, Deputy Executive Secretary and General Counsel for the Teachers Retirement System. Bo, same question. Please identify yourself for the record and go ahead with your presentation.
Good afternoon, Mr. Chair, board members, Bo Barnes, Teachers Retirement System, Deputy Executive Secretary and General Counsel. And my answer is very similar to what you just heard from JFRS and also from KPPA. We don't own any crypto companies. We don't have any direct exposure in crypto, and haven't and don't plan on it either. It is speculative. For TRS, we do have investments in Meta, the parent company for Facebook and Instagram. Our holdings in Meta, about $48 million. About $25 million of that is passive. And by passive, I mean it's just in an index fund. And Meta is a really, really large company, of course. So if you have an index fund, like the S&P 500, Meta is going to be part of that. So 25 million of the 48 million is passive. That represents really a little less than two 1/100ths of 1 percentage point of TRS assets under management. So we have not been harmed by crypto. We've not been harmed by Meta. I think there was some concern about Meta because at one point for less than a year they had this pilot program where they were looking at a crypto electronic currency payment plan. They abandoned that plan. Summer made the decision and ended it September 1st, I believe. But it was an infinitesimal amount compared to the company that has revenue of about $10 billion a month. They sold the whole project for $200 million for a slight loss. So no impact on TRS. This project did not weigh into our outside managers' decisions to actively invest in Meta. They saw it as de minimis. So pretty much the same report that you heard from the previous two retirement systems. And I'd be happy to take any questions, Mr. Chair.
I have a question from Representative Plessy.
Thank you, Bo. It's good to hear about the cryptos and everything. I have a question, and I should have probably asked the fellow before you. I can't remember if it was TRS or if it was KPPA, but several years ago, there was testimony at that desk saying that the low Fed interest rates were harmful to pensions, and that when federal interest rates comes up, that should help percentages in pensions. Is that something that you maybe could speak to?
Well, there's one thing. There's a couple of things here. And again, these questions and the answers to these questions can be a little more complex than what I'm going to say here. But when federal interest rates go up, you do have a greater return on fixed income vehicles. But those rising federal interest rates, and if anyone else wants to chime in, any of those rising federal interest rates also are a reflection of inflation, and inflation is bad for the markets. So you have more downside typically in that kind of environment than you have upside.
Okay, thank you.
Any other members have any questions at this time? I want to thank all the presenters for coming forward on this. This is just subjects that are in the media a lot and a lot of discussion. We thought it would be good to know exactly where our pension systems are in regard to these exchanges. Our next item of business are legislative proposals for consideration. We have three pieces of legislation to discuss today. Before I begin, Chairman Higdon and I have discussed this, and we're not going to make any recommendations today. We anticipate there will be more legislative proposals in our January meeting, and those recommendations will be made at that time. But we are having the presentations today so that we can have questions, feedback, and discussion on this. Since the first two on here I am presenting myself, I'm going to turn the meeting over to Co-Chair Higdon.
Thank you, Mr. Chairman. And while you're getting ready there, I want to recognize that my grandson is with me today. He's in the back there, David Nagel III. Wave there, David. I guess he was bored today, so he decided to come to Frankfurt with. And hopefully it didn't hurt him too bad. Also want to mention one of our Senate members. This is his last meeting, Senator Thayer. He came on we added additional members. earlier in the year, and Senator Thayer volunteered to hold that position until we appointed someone else. So we have some new members coming on next, starting in January. You do?
Thank you, Mr. Chairman. I've enjoyed my service on the PPOB. Since it was my bill that created this committee, I guess, serving on it for 12 months was appropriate, but I'm happy to move along. As much as I enjoy listening to Bo Barnes come in here once a month and testify on TRS, I'm going to move over to administrative regs, and Senator Danny Carroll is going to take the spot.
Okay. Thank you, Senator Thayer. I was assuming you came back for 12 months, saw everything was okay, and you decided to move on. Okay, thank you. And also Representative Duplessis, I served with him. He was my co-chair for 2 years, and just want to commend him on his service. And he and I talked a lot during the last 2 years about pension issues, and so I want to thank him for his dedication to this PPOB committee, and thank you for your service and best wishes in retirement. All right, Representative Tipton, the floor is yours. Get your guests to identify themselves for the record, and please proceed.
All right, James Tipton, State Representative, House District 53.
Good afternoon. I'm Erin Surratt. I'm the Executive Director of the Office of Benefits at KPPA.
Good afternoon. Carrie Bash, Staff Attorney Supervisor, Office of Legal Services, Kentucky Public Pensions Authority.
Okay.
Please proceed.
Mr. Chairman, BR 196 is what's, as Chairman Miller knows, referred to as the housekeeping bill for KPPA. And you will see many things in here which are technical in nature. This 215-page piece of legislation has 28 sections in it. So it's a lot of information here. Some of them are technical in nature. For example, where you see the word website was 2 words. Somebody thinks it's better for it to be listed as one word together, not separated, so you will see that. There are several mentions of the Commission on Human Rights. The word Kentucky was added in those places to identify that as the Kentucky Commission on Human Rights, so you'll see those type of references in there. We've also, you may hear me talk about Senate Bill 151 from 2018. We have had, since the Supreme Court struck that down on procedural matters, there are still sections of statute that include that language of Senate Bill 151. So staff has been working diligently over the years to try and clean that language up. So there are some sections here where we are cleaning up that language where that is no longer was real constitutional. So you'll see that. Just to kind of start here in the 28 sections, and I'll try and go through here as quickly as I can. Section 1 made some technical changes, but if you'll look on page 5, there is one change. You'll see this in a couple of references on the bottom of page 5. Previously, it referred to 72 hours. Now, still, all meeting notices and agendas have to be submitted at least 72 hours in advance. However, sometimes the minutes, those dates fall on legal holidays, so it made it difficult to complete that within 72 hours. So in those situations, they've changed that language to 3 business days. That's what that's referring to, and there's a couple others, 1 or 2 other sections in that as well. Section 2, beginning on page 11 of the bill, really defines the system to include KPPA on behalf of the State Police Retirement System. Section 3 is one of the, starting on page 20, is one of those sections. It's where I referred to, it repeals, reenacts, and amends in response to that court case for Senate Bill 151, cleaning up that language. Section 4 of the legislation starts on page 21. Again, it defines system to include KPPA on behalf of KERS. There is on page 34, I believe, of the bill, there is a definition included for agency reporting official. So that definition is in there. You're also going to see another term in here, gainful employment. When we met earlier, I asked the folks at KPPA and staff that we need to have a definition for what gainful employment is. Let me read that definition. It's gainful employment means work in any capacity that is or may be performed with regularity and is or may be usually done for pay, or the pay is received or not received, including seasonal, volunteer, part-time, and on-call work. Everybody good so far? Mr. Chair, I see a hand raised.
Representative DePlessis.
Thank you, Mr. Chairman. Just wondering why were volunteers included in that?
I will defer to my good folks at KPPA.
Representative DePlessis, this is a definition that applies in one specific context, and that is for required reporting that's already in place for individuals receiving a disability retirement benefit. And the reason that it includes volunteer work in that context is just to be able to review that volunteer work to ensure that it's not at odds with the basis for the person's disability.
Okay.
See no further questions.
Okay.
Please proceed.
Yeah, we'll move on to section. Where was it? Section 5, starting on page 34, and in this it's defining KPPA its system as KPA on behalf of CERS, and also on page 48 that definition of gainful employment is included in this section as well. Section 6 starts on page 48 of the legislation, and this deletes a reference allowing employees of participating department who formerly opted out of participation in KERS from opting in to participation later. And let's see, I believe this is referring to membership.
It is. It's referring to members' election to participate in the system when an agency joins the system.
Okay. Section 7 begins on page 50. Again, this section is a Senate Bill 151 change to conform to the court case. Section 8 begins on page 52 of the legislation, and this is it conforms to the existing policy in federal law, and this deals with Tier 3 members who shall receive military service credit only upon their remittance of their employee contributions, and it also makes conformity changes to reflect membership date as reflected in definitions and conform with federal law regarding membership. Now, I'm going to attempt to explain this, and I'm sure they'll correct me if I get this wrong. But it's time to time we have employees who are called to active duty, and if they're receiving their pay, they also to get credit on the retirement, they also have to contribute their employee contribution. Is this I know we covered that in one section, so are we trying to clear that up?
We did. We're clearing up specifically for Tier 3 members who go on active duty military leave from their employment. When they return to employment, they can get their service credit for the time that they were on active duty military leave, that they are required to pay the employee contributions on the salary that they would have earned had they still been employed.
Okay, I'm looking for, don't see any questions on that. Section 9 starts on page 67 of the legislation. This specifies the process for members who have their employment reinstated by a court or tribunal order. So if somebody is reinstated to employment, they get their salary. There has to be a process for them to pay their employee contribution to receive that credible compensation. So I don't think I messed that up too bad in that definition, did I? Okay. Section 11 starts on page 71. You're going to see some new language in this section, a new term, the term vocational expert. And I did ask them to provide a definition for vocational expert. Since this is new, I think I understand what you're doing here, but I'll ask KPPA to explain why they wanted to add this section and how it will apply, I believe, in disability retirement situations.
Okay, we are asking that we add the ability to have employment reviews. So as part of the disability process for members who are receiving disability benefits, if they are go back to work, then they have to have that employment reviewed and approved prior to doing so. Currently in the statute, that employment review is required to be reviewed by a medical examiner, a doctor. We feel that a vocational expert has better expertise in being able to make the proper determination. Thank you, Representative. Determination on the employment reviews and the physical exertion things. So we're just asking, it's a may, so it still allows the ability for a medical examiner to provide these reviews, but it also gives us the ability to use a vocational expert if we decide to contract for those services.
Mr. Chair, we got a hand up down here. Over here.
I'm trying to read along with you here. Okay, Chairman Petrie.
Vocational expert, would this correspond over to vocational expert that's used in Social Security disability cases with the same type of data analysis and qualifications, or is this something entire? Have you even looked at that?
I'll admit to not being entirely familiar with the Social Security disability process, but we have attempted to clarify the requirements for certification that a vocational expert would have to have in order to do these types of job reviews.
Let me
comparing
read
job to job.
It has a definition for vocational expert in the bill.
Yeah, all I'm saying is you may want to look and make sure that the vocational experts that already exist and do this type of work in the context of Social Security disability determinations, it's a ready and able and willing and experienced workforce for this type of thing. You may just make sure your definition doesn't exclude that group of people. That's all.
Okay.
Thank you.
All right, very good.
See no other questions? Please
Okay.
proceed.
Section 12 starts on page 80 of the legislation, and this would clarify repayment procedures for members who receive a refund in error, which I understand sometimes happens, and for members who have taken a refund and subsequently had their employment reinstated and make technical changes. Okay. Section 13 on page 82, it clarifies the process for retired members whose employment is reinstated. Any questions on that? There is an additional part in section 13 on page 97, and this deals with it would rephrase independent contractor and leased employee provisions relating to when a retiree returns to work the same employer to clarify that the authority, KPPA, has the exclusive discretion to determine whether the employment arrangement qualifies and to comply with federal law. Would you all expand on that just a little bit, because I think this is important for everybody to understand?
Yes. Federal law requires that members who are retiring, before they reemploy with the same employer from which they retire, observe what's called under federal law a bona fide separation from service, or a good faith severance of the employment relationship. And this clarification in paragraph H on page 97 sort of gets more into the details of what that separation has to look like. It has to be a separation of the employment relationship, and also prevents members from turning around, who are retiring, from turning around and going back to work with their same employer under an independent contractor relationship. So that is what this provision attempts to address.
Okay. Section 14, starting on page 101, would permit voting, and this is in regard to board members, prevent voting by telephone in trustee elections. Also specify that retirement allowances accounts in subsections 13F and I change the name of their annual report to ACFR. I don't have that in front of me right now, but I believe that is to conform with national organizations' terminology. And it would change the posting, again, it would change that posting deadline from 72 hours to 3 business days. And I believe if this is approved, that KPPA would establish administrative regulations to how the telephone voting would take place. We had that conversation. Okay, section 15 starts on page 119, and this is a section that we had quite a bit of discussion about. If you're on page 119, on line 5 of the bill, subsection 5, and I'm going to read the entire subsection 5 and then highlight the added language so we're on the same page here. It reads, based upon market value at the time of purchase, the board shall limit the amount of assets managed by any one active or passive investment manager to 15% of the assets in the pension and insurance funds. This investment limit shall not apply to the assets managed internally by the authority's Office of Investments. That is the added language there. And do you all have any additional comments on that and why that is necessary, in your opinion?
That is a request from the executive director and the Office of Investments to clarify that the limit does not apply to assets internally managed. It was the understood intent by the KPPA. It's the KPPA's understanding that that was what was intended when subsection 5 was put into place originally.
Anybody have any
Yep,
questions?
Mr. Hicks has a question.
Yes.
Is that just a belt and suspenders to the original language? Because it seems to be redundant of the sentence preceding it.
Could you repeat the question?
I think I'm curious why the first sentence doesn't already do that. Why the added sentence was necessary. Meaning that you don't have an active or passive investment manager inside KPPA.
Is the first section referring to outside investment managers, and the additional language referring to internal investment management?
That is the KPPA's understanding of what was intended by that subsection, yes, was to apply to outside.
Which is the way it reads, and that's why I was wondering why the additional language was needed. If it's outside, it's not inside. Thank you, Mr. Chairman.
Yeah.
With the housekeeping bill, it's the intent of the KPPA to clarify anything that may be ambiguous, and it's the preference of the KPPA to have that on paper rather than just implied by, the external preamble on that first sentence in subsection 5.
And I'll just make this comment, one of the reasons we're presenting these bills in Public Pension Oversight Board is to ask questions. And I'm more than open to any questions or concerns that members have before we have a final version of the legislation. Also, in section 15.
Just give me a second there, Mr.
You
Chairman.
go right ahead.
Chairman Petrie has a question.
Yes.
So following up on Mr. Hicks's question, if I understand 5 wouldn't be in conflict, first sentence to the second sentence, clarifying what? Like, is there a reason? Is there some event, some lawsuit, some allegation, some restriction, or what even prompts the necessity of the sentence to be added in?
Representative Petrie, I'm not personally aware of any lawsuit or any particular event that's prompted the requested change, as far as I'm aware. And again, I'm not privy to every conversation. That it was just in reviewing the statutes, the KPPA Executive Director and Office of Investments, looked at that and had a conversation about whether it was sufficiently clear regarding the internal management of assets.
All right, thank you, Mr. Chairman.
Thank you. Representative Graham Leader Graham has a question.
A question, Representative Petrie asked it, so I'm fine. Thank you.
Okay. Floor is yours again,
Okay.
Mr. Chairman.
Continuing on with section 15, and that next, actually subsection 6 on line 8, the language originally says that all contracts for the investment or management of the assets of the system should not be subject to these KRS chapters. That's the Model Procurement Code. And this would add the administration, contracts for the administration of assets. One of the questions I had, could you clarify to the PPOB what these type of contracts would be?
My understanding is these types of contracts would be for the facilitation of the investment and management of assets, so software that's used to track investment and management of assets.
We're good. Section 16 starts on page 120, and there are actually some new provisions in this section dealing with it changes the process for the review of the application for disability retirement benefits by medical examiners. And as I understand it, there are a group of 3 medical examiners currently, and they would review the information, and if 2 or 3 of those members approved it, the disability would be approved. The change in the statute would say that there initially would be 1 medical examiner who would review the information. If that 1 medical examiner approved the request for disability, everything would move forward. However, if that 1 medical examiner did not approve the request for disability, they would then bring in a second medical examiner who would review that information. If that second medical examiner did not approve of the disability at that point in time, the disability would not be approved. However, if that second medical examiner did approve the disability, it would then go to a third medical examiner to essentially break the tie. So it would actually potentially expedite those disability retirements. The members would always have due process to appeal this. Anything you want to add to that?
No, I think we have a question.
Okay.
Representative Graham has a question.
Just to ask the question in regards to the time frame of those 3 evaluations. How long will it be? I haven't gone through this whole thing, but is there a time factor between the first to the third, if it has to go to a third?
There is no time factor in the statute. It's my understanding from doing some research that the reason it was moved to send the disability claim to all three medical examiners at once was to expedite the process for the members because of the time that it was taking to get that decision back to the members. So previously I don't know what year, it's been several years ago, but it did only go to one medical examiner to review. That was not efficient for the member. We have recently, within the past couple of years, contracted with a medical managed review organization, MRO, that does the medical reviews for us. So we that is no longer an issue. That was one of the issues that we looked to contract out these services to a vendor, was because we were having problem getting medical examiners on contract, retaining them, and getting timely reviews. So that is no longer an issue with our vendor. So we felt that it was appropriate to kind of revert back where we were several years ago, and that our members would still get a timely response if we moved to this structure.
Thank you, Mr. Chairman.
Mr. Hicks has a question.
Yeah, if you were to guess, how long does it take now and how long will it take tomorrow? What would you guess?
Well, I would say the last time we looked at it, so our vendor not only does the reviews, but they ensure that they have all of the medical from the time the member files a disability claim. They are in charge of making sure all the medical information is in and prepared before it is sent to the medical examiner. That process from beginning to end, the last period that we looked at was taking about 4 weeks. I do not know exactly how long it was taking from the time that all of the medical records were sent to the doctor to review the claim, but I would anticipate probably not more than a week to 2 weeks for the medical examiners to make the review.
Auditor Harmon has a question. Representative Graham's going to take your place.
I just want to. Did you recognize me?
Yes.
Okay, thank you. I just want to go back to it. So with the way the evaluation system, say if the first one says no, when you submit it to the second person, are they aware of what the first recommendation was?
No.
So it's very clear that you keep it separate. I think it needs to be said that it's not shared with each of the doctors.
That's absolutely right. They are independent reviews. Each doctor does an independent review. So they do not know that if they receive that claim to review, they don't know at what step in the process that is. That's not information that's shared with the doctor.
Senator Neal has a question.
Thank you, Mr. Chairman. I'm just curious, if it's denied, is there a reason why it has to go through 1, 2, 3 as opposed to 2 independent as part of the next step?
It goes, if on the first review they are denied, then it goes to a second reviewer. If the second reviewer denies, then it's a denial. That's no different from today.
I understand that. My question is, I'm talking about time. That if it's denied, the question then is to see if that's valid and give that due process better airing. What would be the objection to just going, if it's denied, going to 2 examiners at the same time independently because of the time issues?
Instead of the 3?
Yeah. No, it still would be 3, but it's a sequence. Instead of having 3 sequences, you have 2. You have a denial, then you have 2 independent reviewers, and then you get your result. Why would you go to a third? Is there a money issue or something?
Because each medical examiner is paid independently for each review. So that's why we wouldn't send it until.
Thank you.
Representative Fleming has a question.
Thank you, Mr. Chairman. Could you just give me a little more clarification of the time frame in terms of things being processing now to what you're being proposed? That would include the 2 additional examiners to go through that process. You said, referred to it's going to be expedited. So could you put that in a more of a concrete time frame for me?
Well, what I'd say is that the last review of the time frame that we looked at is from the time that the member made the disability claim through the time that the decision was made. Okay, so which is taking about 4 weeks. I would say that prior to our contract with IMRO, I would say it was 3 times that length to get just a review back from our medical examiners after we had sent all the medical records to them. So what it would do is that 4-week time frame, if we go under this process, so if it was approved on the first review, then it would be done at that point. If it's denied and it goes to a second doctor to review, then I would say it would add another week to 2 weeks onto the time that the member gets the decision. And then the same thing if it had to go to a third review. But it would, the time that it takes to get a review now compared to prior to having this contract, there's a significant difference, and it would just be a cost savings under the new structure that's presented here.
And the follow-up question, Mr. Chairman. So you said about 3 times, so you're looking at a couple months, quite a few months for it to go through on the current process. But on this new scenario, even after going through 3, you're looking at maybe 2 to 3 weeks. Is that correct?
If under this new process, it would probably be somewhere in the time frame from about 6 to 8 weeks, I would say, if they go through all 3 reviews. Prior to the contract that we have with IMRO, it was taking approximately 12 weeks to get a decision back for our members on their medical reviews.
Okay,
so it's still a shorter period of time than what we had prior.
The contract is specified they have to get back in a certain period of time.
We can look at that. The contract, I don't think, specifies that specifically right now, but that's a modification maybe that we could look at.
You might want to think about that.
Okay.
I mean, you're just saying it's great in terms of expediting the whole process, but if you don't, then you know we're giving each other lip service. So I think maybe think about putting something in black and white to get something solidified.
I think that's a good suggestion. Thank you.
Senator Neal.
I just want to pile on that just a little bit. The process is expedited. Is that language in here?
No.
So if there's some prohibition or some concern about setting a concrete time, you might want to consider putting that kind of language in there, that they understand that this is not something that sits around on your desk. This is something that needs to get done.
Okay.
I'll use my member privilege here. Is that something that could be taken care of for administrative reg, or is that something you actually need to review and have contract negotiations with to determine if that's feasible?
We would have to consider a contract.
Yeah, I think we would definitely have to look at the contract and maybe make modifications there.
May I continue?
Yes, Senator Neal has a follow-up.
I just want to understand, why would that not be put into the legislation itself, expedited? It's just a word that says get it done. I would ask you to consider it. That's okay. Don't respond.
Yeah.
We're fine.
We can certainly consider that.
I don't think there's any problem with considering adding the word to expedite the process. I think we have to be careful if we put specific limits in here.
But you like the language.
Specific time limits, because life happens.
But you like that language, expedited.
I have no problem having a conversation and see what I have no problem with it. We'll see how it might fit into the language. We can look at that.
Okay, so we can offer an amendment, and I can have your help.
Well, like I said, this is not the final version, so we've got time to.
I'm just teasing you. Don't worry.
We got time to work on this, Senator. Okay. Thank you, Mr. Chairman. We're over halfway there. Section 17 starts on page 128. On page 128, and currently in statute, if you're on page 128, it refers to somebody who knowingly is aware of something or causes to own benefits, and this would include civil liability and collection provisions. It adds a provision that if somebody receives a retirement allowance or health insurance benefit to which he or she is not entitled, and that just includes that language in that section to what is already subject to civil liability. Section 18 is on page 131, and again, this is just a repeal, reenact, and amend. And my note says respond to a court case, but I'm pretty sure this is Senate Bill 151 language as well. Section 19 starts on page 141. I'll give a little bit of explanation about this. It would make a technical change to restore language for pre-July 1, 2003 General Assembly members whose spouses and dependent children are eligible for a percentage of health insurance premium coverage. This is in non-codified language currently in Section 86 of House Bill 9, but it's my understanding maybe it was taken out of the codified language, and this request is to make sure that future generations understand that this is an inviolable contract provision. I get that clear as mud? Okay. Any questions on Section 18? I'm sorry, Section 19. Also on Section 19, on page 142, it would specify that excess dollar contributions for hazardous retirees may be used toward their spouse and dependent health insurance premiums, and this conforms to existing policy. They asked to put this in statute. Also, there is a small reference correction on page 147 of Section 19. Going into Section 20, starting on page 147, this specifies that the $5,000 death benefit is payable to the beneficiary and not the member. It also specifies that it is not garnishable as an asset of the member's estate unless there is an outstanding debt owed to the system and payments are made after the death of the member and not repaid, or the beneficiary is the member's estate. Any questions on that? Section 21 makes a conforming amendment to Section 22, and Section 22, starting on page 156, is a change to conform with federal law regarding membership. There are some deletions there. Section 23 again refers to the vocational experts. As I believe the previous section was KERS and this is refers, so it's also referring to CERS. We had that discussion about vocational expert, and this is the language, same language as we saw in Section 11. Section 24 also is the same as Section 18, where we talked about the House Bill 9, Section 86. That is the same language in there. Section 25 is also the same language specifying about the death benefit in the CERS statutes. Section 26 is consistent with what we saw in Section 13 about clarifying the process for retired members whose employment is reinstated, and the rephrase independent contractor and leased employee. Section 27 is consistent with Section 14 to permit voting by telephone, and also changing that name in that annual report to ACFR, and then the 72 hours to 3 business days. And finally, Section 28 conforms to Section 3 and 18. Mr. Chairman, that's all the sections I have. Does anybody have any questions?
Representative Miller's going to thank you. Representative Miller.
Thank you, Mr. Chairman. Chairman Tipton, over my 6 years in the majority, I think I passed about 4 or 5 housekeeping bills for the various systems, and you've done a much more thorough job than I ever did. I will say that. But there's one thing that I would always say is that what, if any, is the fiscal impact or actuarial impact of this bill as it's written today?
As it's written today, I do not know. I would ask KPPA.
They will usually give you an idea if they think there is or not. So.
No, most changes are just technical changes, so there shouldn't be any fiscal.
That's what I thought. There was one section I thought, well, maybe it does.
I didn't really see anything that I thought would have a fiscal impact.
Yeah, just a reminder that we any retirement bill must be accompanied by
Sure.
AA
So we'll-
actuarial analysis, just for
So
the,
we'll get,
just
we'll,
FYI.
we'll have that done.
And I would just say it has already been sent to GRS.
Okay,
review,
to do
so,
that.
Yes.
Okay.
Mr. Chairman, please proceed. It looks like you have no questions. You
Okay.
explained that one very well.
Okay. My folks from KPPA they're happy to be excused. If that piece of legislation did not get your attention, the next piece of legislation will get your attention because it's dealing with the legislative retirement system in the LRP, Legislative Retirement Plan. Some of you may know this is BR 435. I have filed the legislation in previous years dealing with LRP. I had not been successful. Chairman Higdon and I talked about this, so I filed a bill again. However, I have made some revisions.
Mr. Chairman, let me
Go ahead.
remind the folks from KPPA to stay. We might have some further questions toward the end of the.
Absolutely.
Thank you.
Absolutely. But
Please proceed.
I did make some changes to my previous legislation. Essentially, I'm just going to go through what this bill will do. Right now, this bill is going to impact Tier 3 members, those who start service in the General Assembly after January 1st, 2014. So what it would do, it would close the LRP plan to new members effective July 1, 2023. As you know right now, new members of the General Assembly have an option of choosing the LRP plan or the KERS non-hazardous plan. Also, if the bill passes, existing members who are in the tier, what I'll call the Tier 3, post January 1, 2014, would have their plan balances transferred to the KERS non-HAS plan effective December 1st, 23. There are some other technical changes to that, and let me explain my rationale for that. I think we have too many plans, and we have a legislative plan with just a small amount of members. And a lot of times with a small amount of members, the actuarial reports get skewed because of that. And I asked the question, why do we need a separate plan? We're in the plan for the LRP plan and the current KERS plan are identical. They're hybrid cash balance plans. I think Senator Thayer knows how that plan works. I believe you had a little bit to do with that in Senate Bill 2. So I've even heard a little birdie told me that might have originally been part of Senate Bill 2 to do this. But it was changed. Maybe it wasn't added in the final version. And at some point in time, the existing members in Tier 1 and 2, their plans are going to finish up at some point in the future. And then all we're going to have left are the cash balance plans. And why do we need a system in the future that where KERS is the same plan and could actually do this? So that's my rationale for making that request. It would also provide that any future changes to the LRP statutes to become effective after July 1, 2023 shall not be part of the inviolable contract. So going forward, there would be no inviolable contract provisions added to LRP. And that's included in two places in the statute.
Mr. Chairman, you have Representative Miller.
Go ahead there, Representative.
Thank you. I regret I won't be able to vote for this, but
Okay.
But it's good. I like what you're doing. It makes tons of sense, and I would speak highly of it to my successor.
Okay.
So thank you.
Thank you, Mr. Chairman.
Yes, Representative Plessy.
While we're stopped, I too agree with Representative and Chairman Miller. I like the thought, the idea of this, but I'm just wondering about the math of this. We've heard from KPPA many times, multiple times, that they're at 18% funded, and because of their funding ratio being so low, they have to be quite conservative in how they invest their money. Whereas we see TRS, who's in a better position, not as good as we need them to be, but in a better position, and they're more aggressive with their investments. And hence they typically have a much higher return than KPPA because of that ability to be more aggressive. The same holds true with the legislative and judicial. We haven't put any money, as I understand it, in the last 2 budget cycles, 4 years, into the legislative pension fund. We've instead diverted every dollar that would have gone to LRP into KPPA, doing exactly kind of what you're saying, diverting the money over. But because LRP is in such a good financial status, they can be aggressive with their investments. They can maintain their positions and not need the cash infusions that the other systems are doing. So it seems like to me we're taking a system that's healthy and we're pushing it because it does have the appearance, a good appearance, but we're pushing it into a system that we're trying to get healthy. Why don't we do what we're doing now and just keep putting the money that would have gone to LRP over to KPPA, which is essentially what you're saying doing, without having to do that, because it allows us to stay aggressive with these smaller system.
I was going to add that in this statute includes that there will be no funding provided to the LRP until that LRP has a funding level that is the same or less than KERS non-hazardous. So essentially, I'm putting in statute in this legislation what we have by practice be doing in the budget bill.
Which I think is I agree with, but it doesn't address my point of mathematically. By being able to keep LRP the way it is, and I'm getting out, so it doesn't. I don't have a fight in this game. But mathematically, if we leave everybody that it is, that small group of people, you can still stay aggressive with your investments. Whereas if you move those people over to KPPA, every one of those will be in a less aggressive, less growth manner. So that doesn't seem to me to make mathematical sense to do. It looks good, but we're doing the same thing by shifting the money.
I understand your question, and I've had a lot of discussions with staff on this issue, and I understand your question. The amount of dollars we would be transferring are minimal to what would be in the KERS non-hazardous portfolio. I'd like to say that the amount we're transferring would enable them to be more aggressive, but it's not, because it's a very minimum amount. But what's going to happen is right now we have members who are choosing. Some members are choosing to go KERS non-haz. Some members are choosing to go on LRP. And still, 20 years from now, 30 years from now, we're going to be dwindling down on the LRP members who are Tier 1 and Tier 2, and we're essentially going to have a cash balance plan sitting out there, which is identical, is funded identically. I'm not talking about investments, funded identically to the KERS non-haz. And my rationale for this is, does it make sense to have that second fund out there? And if we don't start now making this change, we're going to continue to see that trend. I have also been told, and don't ask me to explain it right now, but that there could potentially be a benefit to members going to KERS dealing with health insurance and the contribution funds. I need to do a little more research on that and get back to you all on that, but I have been told that could potentially be the benefit. But I understand your question. And again, my last point on this was that I just made that on the funding, and that's essentially what the legislation does, and be happy to take it. I do have one question for the PBOB.
Before you ask your question,
Okay.
Leader Thayer has one
All
for
right.
you.
Thank you, Mr. Chairman. Thank you, Representative Tipton. I'm going to need some convincing to support your bill.
Yeah.
We can talk about that
Sure.
offline. But I can tell you one thing that would sweeten the deal for me. Put in the Senate Bill 151 provision that would eliminate pension spiking for legislators in Tier 1 and Tier 2, who were allowed to change their high 3 to a lot more money when they go to an executive branch job. I've been opposed to that philosophically for a long time. Passed it a bunch of times. It's failed in the House a few times. Was in Senate Bill 151. I think it's time to restore that. Put that in the bill and we can talk.
Leader Thayer, I had that in my previous versions of this legislation, and I actually had it drafted that way this time. As you said, there have been resistance. I have been told that it would be a violation of the inviolable contract.
Then let them sue.
That's always been my question. But Leader Thayer, if this bill were to pass and get to the Senate, and you wanted to add that in there, I would not. I would still sleep at night.
You read my mind, Representative Tipton.
There is one other provision that I did not include.
Representative Tipton, I want to add something to
All right,
Leader
go ahead.
Thayer's. I came to the Senate in 2010. The first bill I filed and passed on the Senate floor was a bill to repeal reciprocity, and which is legislative spiking of the pension. So this subject's been around for a long time, and a lot of attempts to roll that back. So please proceed.
And the other provision that was in my original legislation dealt with the benefit factor. Legislative retirement members receive a benefit factor of 2.75%, or 2.75. Members in the KERS non-HAS is 1.97. I also changed that language originally. It was my thought process to do that this year as well, where for future years of service, the benefit factor would be the 1.97. Again, I stripped the bill down for simplicity and to hopefully maybe get some action, but I am open to those other suggestions. And I do have a question for the members of PPOB that I considered in adding to this. The judicial retirement system includes two plans, the legislators and the members of the judiciary. Now, the judiciary is a larger plan than the legislative plan, but for new members going in under this Tier 3, they have the same plan. It's a hybrid cash balance plan. And I wanted to start out with legislators, but what does PPOB think about adding the members of the judicial retirement system to this provision as well, in moving all their new members into KERS non-HAS, and moving those existing balances into KERS effective December 1, 2023. I throw that out there as a question. You don't have to answer me right now, but I wanted to just get your thoughts on that.
Chairman, does current law, those judicial members in Tier 3 have the option to go into KERS anyway?
I believe they have that option, yes.
Okay.
Just like the LRP. And I also believe that people who are elected, the judges that have prior service, staff can correct me on this, who have prior service in Tier 1 or Tier 2, stay in that. Am I correct on that, Brad? Am I saying that right?
Some of them do.
Yes, some of them do. But this would be for new members into judicial retirement and the existing members who are in judicial retirement Tier 3 after service after January 1, 2014.
See no further
All right.
questions there, Mr.
Okay.
Chairman. You did a good job. While you're coming back up here, we want to call the KPPA folks back to the table. We have one quick question for you. And probably the legal staff is probably the best one to come. This meeting couldn't adjourn today without asking about the big news this week of the lawsuit against KPPA. And you're probably not the one to comment on that, but you're the one that's here today, and this is a question that needs to be asked. And I know that there's some things you can't say and some things you can. So your comments on the lawsuit by one of our former employees.
The KPPA comments is that the complaint filed by former employee Stephen Herbert contains demonstrably false allegations. KPPA regrets that it will be forced to spend resources to defend against Mr. Herbert's lawsuit, but the KPPA is confident in the defense of the claims that Mr. Herbert has asserted. Any inquiries concerning the complaint should be forwarded to the KPPA's communication teams. Beyond this comment, the KPPA cannot respond any further.
Thank you. And Mr. Chair, do you have any Any further questions?
I was going to put this at the end of the meeting, but since we're discussing it now, Representative Wheatley, we haven't forgot about you. Again, we all saw the newspaper articles on Friday. And of course, these, as you understand, these are very serious allegations. I've had a conversation with Co-Chair Higdon. I've also had a conversation with the incoming co-chair of the PPOB, Representative DJ Johnson, who's here. Good to have him here today about this. And we'd like to make a recommendation to PPOB that we send a letter to the co-chairs of the Oversight and Investigation Committee and ask them to work with us together or independently to review these allegations. We're not prejudging, but we have a responsibility to the citizens of the Commonwealth to review the facts of the case and do an investigation. Does anybody have any questions on that proposal? If not, do I hear a yes, Representative Fleming?
And I'm not any questions about the proposal. But can you outline what was read? Because I understand it was in the Herald Leader, and I have not read the Herald Leader. Could you give a little? Me neither. I don't read it, but anyway.
Me neither. I think I.
You just described.
I think I saw some articles in the Courier Journal where I saw it was essentially the same information.
Okay.
There was a former employee of KPPA who I believe was let go at some point in time. And in the lawsuit, the allegations, again, you know that's only one side of a lawsuit, are asserting that there were mismanagement of funds, and even I believe the reference was to embezzlement of funds. And again, we're not prejudging. That's what's in the litigation. But given the serious nature of the allegations, I believe it is prudent that we as the General Assembly proactively look into this.
Thank you. I appreciate that. So I just want an explanation.
With that said, do I hear a motion from the members of PPOB? Yes, Senator Higdon, you have
Motion.
have a motion by Senator Higdon and a second by Representative Duplessis that we do address that letter to Oversight and Investigations Committee. And just so you know, the one reason that we chose that committee is that committee does have subpoena power. Any other comments or discussions from members of the committee? All those in favor say aye. Aye. Any opposed, no. The motion carries. Thank you all for answering the question the best you could under the circumstances. The next item, if Representative Wheatley wants to come to the podium, anybody, I don't know if he has anybody with him tonight, is going to give us a presentation, legislative presentation on BR 276. So Representative Wheatley, please identify yourself for the record and proceed.
Thank you, Mr. Chair. Jennifer is handing out another folder that the chairs have had a glance at. It's simply a document that's on KPPA's website and a NASRA report on COLAs that was handed out to the committee in July. And it just has some bearing on this piece of legislation. It's an honor to be here. I am Representative Buddy Wheatley, 65th District, and this is a presentation on BR 276, which has had an actuarial analysis of it. And thankfully, Mr. Hicks is here, and he could write this check pretty quickly, I think, if we just all agreed. But there is an analysis that states how much this COLA, which is not truly a COLA, is, because we do have restrictions. So I'm going to real quick, and this will not take nearly as long, I don't believe, to go over what's in this piece of legislation and the way we should look at it, I think. Since 2012, KPPA members have received 1.5% compounding increase in their annual pay. In contrast, Social Security recipients have received 31.1% compounding interest since 2011. And again, this piece of legislation addresses KPPA members only, as The audience will probably know that there are other retirement systems not addressed here, and that's the teachers' retirement system and the judicial forum retirement system that we just talked about. So this is for KPPA members only. And we know that the teacher's retirement has a pre-funding 1.5% COLA, and the other retirement system will receive ad hoc raises if they're agreed to by the General Assembly, which is the current case, along with the legislation from Senate Bill 2 that allows a COLA, a compounding COLA, as if the prescriptions of Senate Bill 2 are met. So, and it's important to know that this bill here refers to a simple adjustment, inflation adjustment, and simple means it's a one time, it's only this time, and it doesn't compound. It affects, as I said, about 124,000 members of KPPA, and the average current annual amount through a KPPA pension is $18,569. You will see that through some of the legislation that this piece of legislation incrementally deals with increases based on your current monthly amount. And the bill would grant an additional monthly, a 13th distribution check in years 2023 and 2024 based on a current member's amounts. So maximum benefit, 100% would go to those members receiving less than $30,000, with diminishing amounts going to members at more than $30,000, more than $50,000, and more than $100,000. And yes, we do have very few members who do receive $100,000 or more as a pension benefit. If you go to KPPA's website, you'll find a history of COLA increases for Kentucky retirees. You'll see that since 1960, there's listed there, and this is what's in your orange folder, 43 official benefit increases since 1960. And here's what some surrounding states do. This is also in your orange folder. If you go through the document, you'll see that Tennessee state employees and teachers receive an automatic COLA up to 3%. Ohio distributes 3% raises to state employees with variations for their teacher system and police and fire systems. Indiana and West Virginia retirees receive an ad hoc increase as approved by the legislature. And funding from this bill, as I had partially mentioned, would come from the Budget Trust Reserve Fund in the amount of $326 million, a little over $326 million for each year, and that would be for consecutive years to be distributed in June of 2023 and 2024. And of course, this bill is here for discussion during the summer when we discussed a type of COLA that our retirees so duly deserve. Many variations have been talked about, and of course, there's limitations related to what can be which we don't have a current system of pre-funding a COLA, but this is more of an ad hoc, simple salary or inflation adjustment payment that would raise up a little bit over a long due COLA or adjustment to retirees' pay, which has not happened very much, obviously, since 2008. So this bill, like Chairman Tipton's bill, is open for discussion. We're not here to make any recommendations, but we are here to seriously consider an adjustment that is, we haven't had the opportunity to do anything like this in quite a while, and with the Budget Reserve Trust in the shape that it is in, I think there is some opportunity to do that here, and how we do it, and when we do it, and exactly from what funds they come from. That, of course, is all open to discussion. But at that, Mr. Chair, I'm ready to take any questions.
Thank you, Representative Wheatley. As I read the bill, it actually calls for two separate payments. one in July of 23 and one of June of 24, which would be in the same fiscal year. Correct.
If it is stated that way, it should be stated, I believe, in 2 fiscal years, and we'll look at
Well,
that.
I believe it says July of 23 and June of 24, which would fall in the same fiscal year. So that was just my question, the clarification on that. And the question being, since we're going to be coming into 2024 for a budget session, would it be more appropriate to address that then when we have a clearer picture?
Quite possibly.
Finances. Okay,
Quite
so I just brought that up as clarification. Any other members have any?
Mr. Chairman.
I'm sorry, who? Representative Graham, yes.
And I hope that we can if we need to change it, I hope that we can look at the possibility. We've got a lot of our former people who have worked here, who have retired, and I've said this in many discussions. The people that we have now serving us and across the Commonwealth, they were trained by the people now who are retired. And so I know all of us here that has LRC, that deals with our LRC staff, just think about those retirees. I'm just using that because sometimes you need to bring directly to you, of those people who have trained the people who are now doing the work that we depend upon. It's an opportunity to show not only our appreciation for the services that they have provided, but also for what they have done in terms of orientating people who have come to now serve us and across the rest of the Commonwealth. So I hope that we can work together. I think this is an excellent idea. He's worked with many of the retirees who have talked to, I think for all of us, because we all have retirees within our districts, of the fact of the matter that they have not had a cost of living increase in a long time. So I would hope that as we proceed, that we can proceed in a way in which we try to work with our retirees, as well as work together as legislative leaders to try to come together what we can do in order to make something happen for our retirees, because they've gone a very long time and the cost of living has increased. And right now we know that in particular. So I give that out to everyone who is on this committee, but also a shout out to our members in the House and the Senate. Thank you.
Chairman Miller has a question or comment.
Thank you. And first off, I would like to say thank you for serving on this committee. I really enjoyed working with you over your career and my career.
And right back at you, of course.
And the others on this committee. It's been a privilege to do that. I'm one of the ones that chose to go into KERS when I came back I was in the Fletcher administration for 4 years, so I was in KERS. So within a month, I hope to have my first retirement check, so my perspective is changing on the subject. But I think it's a good idea, but clearly we can't do it without pre-funding it. We can't repeat the sins of the past. By the same token, it's needed. So thank you.
Thank you. And I would just say right back at you as far as serving on this committee with you. I started service the very first month in the General Assembly, and have enjoyed it tremendously. And it might be kind of wonky to a lot of other legislators, but it's something I'm involved in, and it has been a pleasure myself. And this is not part of a a COLA. It's not compounding. It's an ad hoc, one-time amount that we hope that we can get to our retirees.
Hey, turn the floor with Co-Chair Higdon.
Thank you, Mr. Chairman. And Representative Wheatley, thank you for, I know you've worked very hard on this, and it is a issue that's certainly for real. And talk about the since 2012, since majority of state employees received a COLA, we have some state employees that did not participate in Social Security. So not only they're not getting a COLA from pension systems, they're not getting any additional. They're not getting Social Security. So, a lot of recipients of KERS or KPPA retirements did have that supplement of Social Security going up. They had a little relief, but we do have some out there that received no relief. But a couple things that personally I think we should look at as we go forward is, of course, it is the law. It says that no COLA will be made until the funds are 100% funded. Like Representative Tipton said, Jesus might come back before we get KRS to 100%. But we're working on it. We're up from 13% not long ago to pushing 19%, so we're headed in the right direction. Most likely, a COLA for KERS would come from the general fund. CERS employees are employed by the cities and counties. We need to have a big discussion with League of Cities, KCO, this CERS board and stakeholders about a way for CERS to do a supplement. And, and it's a perfect time because they received CERS contributions went down, I think, 3% this year. So that's something to obviously look at. But I just want to make those points that CERS, the liability for them lies strictly with the cities and the counties. And to my knowledge, the general fund has never made a contribution to CERS, other than we do have our circuit court clerks are in CERS, and so the general fund does make a contribution to CERS for our employees that are in that system.
Thank you, Mr. Chair, for bringing that up. That has been a part of our discussion of how to fund this, because yes, that the contributions come from those individual cities and counties and local governments. We think that there might be some past precedents where more general funds have been used or allocated to CERS, but that's a little bit more of a legal question. If we can, there's certainly trust funds that there are restrictions on. So whether or not all of those funds can come from the general fund or the budget reserve trust fund, that might need to be looked at. And if there is a way, of course, a way that is will make it easier on the CERS program to allocate an additional 13th payment for two consecutive years. I hope we do look at that.
Thank you.
Next question is from Representative Duplessis.
Thank you, Mr. Chairman, and thank you, Representative Wheatley. You and I are going to ride off the sunset together, brother.
Yes.
It has been a pleasure serving with you. I have found you to be not easy, but a pleasure to work with. I don't think I was easy to work with either, but we always saw
pleasure
that we were trying to get to the end goal. And I agree with what you're trying to do here, and that's to get a COLA for the members of KPPA. And I would hope that the current representatives and senators would as well. This year is it's been the worst inflation since the Carter administration. You don't have to go very far to go to the grocery store to see the dollar doesn't go very far. And there's just some things that I would think about if I was driving a bill, and I'm not. But if I was, the millions that we're talking about to do a one-time COLA payment, what would that do if we put that to pay down the debt liability? How big of an impact would that be? Do you know?
Well, it sounds like you're talking about doing a $326 million a movement of funds to the
pay down the debt.
To pay down the debt. And as I think we have had recent additional payments to pay down the debt in the last few years, you'll see that $326 million will have an impact, but it won't have that great of an impact. And something to recognize here, and I'm glad you brought this up, is that, we are a state that does not have pre-funded COLAs right now. And if we don't do things like this, as we have seen for almost 10 years now, there will be no raise. We're not going to get to 100%. I know we kind of can joke about it, but we're not going to see any raises for those employees who have dedicated their lives. And many, I know half of the firefighters or more retirees do not get a Social Security benefit. They're not eligible, and they will never see a raise if we do it per strictly the current language in KRS 61. So what would it do to pay down? It would pay it down some, and we would probably need an actuarial analysis to really get a good number, but I don't think we're going to raise it up by 10, 15, or 20, or 30% with that kind of payment.
Okay, and I like paying off my debt, so it lets you live better when you're out of debt. But look, just something to think about, and I'll use the words that you just used. Those employees that gave their life to the state, their life to the state. You and I, well, myself, I've worked 8 years for the state. A lot of folks come into a job and work a few years and leave, and they're going to be on their, quote, retirement rolls if they work long enough to get vested. But then there are other employees that did put in a full life's work. So I'm more inclined to somebody who put their life's work into the state and has a fixed income with no COLA to help those folks versus the thousands of people that are on the rolls like myself that have other means, that have other retirement plans, that have other things coming to them that I'm not solely reliant on my state legislative pension plan. So is there a way that we could be smarter with our money and help those who are the lifetime workers who don't have the other things like myself and others who've worked other jobs, but those that work 30, 40 years for the state?
Thank you, Representative Duplessis. As usual, you bring up excellent points, and this is a point that has been, we talked about, length of service in order to get a inflation adjustment pay. So we tried to come up with particularly some language that we could possibly do that with, but a big part of this was to deal with or to handle this through an administratively easier way to distribute the dollars. Once you get to people that are vested for less than 5 or more than 5 years, less than 10 years, where do you break down those dollars? Where do you break down the percentages? How many years, and then how much? It really would just got to be too much to put into legislation and to not have the battles over too many different aspects of a piece of legislation. You can really get bogged down in the numbers, but it is something to consider. This is a bill for discussion right now, and if it's something that the members see as a valuable part of a piece of legislation, I welcome it.
I have another question. Before we get there, I'll just add to Representative Plessy's initial question. In the 2022 budget, we appropriate $215 million additional dollars in the state police retirement fund. The impact of that, prior to that, for every dollar we were paying in to a trooper's employment, it was costing us $1.46 in retirement benefits. That $215 million injection got that down to about $1 to dollar. We also added above the actual required contributions this time about a little over $400 million into the KERS systems this time. So we were able to put additional funds, but however, the total impact actuarially is minimum based on the unfunded liability. And
the difference in those two plans are
so different in size.
Yes.
And we put 479.2 into the TRS system. Again, such a large system, it's minimal. I just want the note that we have put some additional funds, and I'm confident we will try and put additional funds in as they are available in the future. Leader Thayer has a question.
No question, just a comment. Chairman McDaniel is not here today, so I'm going to fill in for him as the Grim Reaper and probably put an end to this conversation and say we're not opening up the budget in 2023. Thank you, Mr. Chairman. Merry Christmas, everyone.
Do I see any other comments or questions this time? Representative Wheatley, thank you for your presentation. Again, thank you for your service to the General Assembly. I will make note to the members, there is a exhibit in your packet, Exhibit 1-1. This was in response, I believe, to our question from Senator McDaniel at a previous meeting, asking for a 10-year projection of the pension and insurance funds, giving some scenarios. So that information is in your packet for your review. I want to make note, it's good to have Representative Hale with us today. Representative Hale is going to be the incoming chair of the State Government Committee in the House. It's good to have him here today. And again, thank Representative Johnson, who will be the incoming chair of the Public Pension Oversight Board. This is my last meeting serving as co-chair of the PPOB. However, I will be remaining as a member of the Public Pension Oversight Board, so you haven't got rid of me yet. But again, thank everybody for your attendance today. And I just want to mention in regard to the last presentation, we're all aware of the situation out there and what the increased costs on anybody are. And I think we're going to continue to look for answers and solutions as we move forward. So we will have a January meeting. Yes, Mr. Chairman.
Yes, I just want to thank you, Representative Tipton, for filling in when the position became open, and it's been great working with you, and I appreciate your dedication to this KPP, our Public Pension Oversight Board.
Okay, we have too many acronyms in state government, but thank you, Co-Chair Higdon, and with that, the meeting is adjourned.